All right, there we go. All right. Well, let's see here now. Looks like we're going good. I think it's working. I don't know. Do. Oh, well, we'll just see. All right. Substantive interest of the enforcing state. First case is Fauntleroy versus Lum, a 1908 case. Justice Oliver Wendell Holmes delivered the opinion of the court. This is an action upon a Missouri judgment brought in the court of Mississippi. The defendant pleaded that the original cause of action arose in Mississippi out of a gambling transaction in cotton futures, that he declined to pay the loss, that the controversy was submitted to arbitration, the question as to the illegality of the transaction, however, not being included in the submission, that an award was rendered against the defendant, that thereafter, finding the defendant temporarily in Missouri, the plaintiff brought the suit there upon the award, that the trial court refused to allow the defendant to show the nature of the transaction, and that by the laws of Mississippi, the same was illegal and void, but directed a verdict if the jury should find the submission of award were made and remained unpaid, that a verdict was rendered against the judgment in suit entered upon the same. The plaintiff in error is in signing of the judgment, but nothing turns upon that. The plea was demurred on the constitutional grounds, and the demurrer was overruled subject to exception. Thereupon, applications were filed against setting up the Constitution of the United States, Article 4, Section 1, and were demurred as well. The Supreme Court of Mississippi held the plea good and the replications bad, and the judgment was entered for the defendant. Thereupon, this case was brought here. The main argument urged by the defendant to sustain the judgment below is addressed to the jurisdiction of the Mississippi courts. The laws of Mississippi make dealing in futures a misdemeanor and provide that contracts of that sort, made without intent to deliver the commodity or to pay the price, open quote, shall not be enforced by any court, close quote. The defendant contends that this language deprives the Mississippi courts of jurisdiction and that the case is like Anglo-American Provision Company versus Davis Provision Company No. 1. There, the New York statutes refuse to provide a court into which a foreign corporation could come, except upon cases of actions arising within the state, etc. And it was held that the state of New York was under no constitutional obligation to give jurisdiction to its Supreme Court against its own will. One question is whether that decision is on point. No doubt, it sometimes may be difficult to decide whether certain words in a statute are directed toward jurisdiction or to merit, but the distinction between the two is plain. One goes to the power, the other to the duty of the court. Under the common law, it is a duty of a court of general jurisdiction not only to enter a judgment upon a parole promise made without consideration, but it has the power to do it. And if it does, the judgment is unimpeachable unless reversed. Yet a statute could be framed that would make this power, that is, the jurisdiction of the court, dependent upon whether there was consideration or not. Whether a given statute is intended simply to establish a rule of substantive law and thus to define the duty of the court, or is meant to limit its power, is a question of construction and common sense. When it affects a court of general jurisdiction and deals with a matter upon which that court must pass, we naturally are slow to read ambiguous words as meaning to leave the judgment open to dispute, or as intended to do more than to fix the rule by which the courts should decide. The case quoted concerned a statute plainly dealing with the authority and jurisdiction of the New York court. The statute now before us seems only to lay down a rule about a decision. The Mississippi court in which this action was brought is a court of general jurisdiction and would have to decide upon the validity of the bar, if the suit upon the award or upon the original course of action had been brought there. The words shall not be enforced by any court are simply another, possibly less empathetic way of saying that an action shall not be brought to enforce such contracts. As suggested by the counsel for the plaintiff in error, no one would say that the words of the Mississippi statute of frauds, quote, an action shall not be brought whereby the charge a defendant, end quote, go to the jurisdiction of the court. Of course, it could be argued that logically they had the scope, but common sense would revolt. We regard this question as open under the decisions below, and we have expressed our opinion upon it independent of the effect of the judgment, although it might be that, even if the jurisdiction in the original cause of action was withdrawn, it remained with regard to suit upon the judgment based upon an award, whether the judgment or award was conclusive or not. But it might be held that the law as the jurisdiction in one case followed the law in the other, and therefore we proceed at once to the further question of whether the illegality of the original cause of action in Mississippi can be relied upon there as a grounds for denying a recovery upon the judgment of another state. The doctrine laid down by Chief Justice Marshall was the judgment of a state court should have the same credit, validity, and effect in every other court in the United States, which it had in the state where it was pronounced, and that whatever pleased would be good to a suit thereon in any such state, and none others, could be pleaded away in any other court of the United States. There is no doubt that this quotation was supposed to be an accurate statement of the law as late as Christmas v. Russell, or an attempt of a Mississippi by statute to go behind judgments recovered in other states was declared void, and was held that such judgments would not be impeached even for fraud. We assume that the statement of Chief Justice Marshall is correct. It's confirmed by the Act of May 26, 1790, U.S. Statute 112, Revised Statute 905, providing that the said records of judicial proceedings, quote, shall have the full faith and credit given to them in every court in the United States as they have by law or usage in the courts of the state from whence the said records are or shall be taken. Whether the award would or would not have been conclusive, and whether the ruling of the Mississippi court upon the matter was right or wrong, there can be no question that the judgment was conclusive in Missouri on the validity of the cause of action. A judgment is conclusive as to all the media concludi, and it needs no authority to show that it cannot be impeached either in or out of state by showing that it was based upon a mistake of law. Of course, a want of jurisdiction over either the person or the subject matter might be shown, but as the jurisdiction of the Missouri court is not open to dispute, the judgment cannot be impeached in Mississippi, even if it were upon the misapprehension of a Mississippi law. We feel no apprehensions the painful or humiliating consequences will follow upon our decision. No court would give judgment for a plaintiff unless it believed that the facts were of a cause of action by the law determining their effect. Mistakes will be rare. In this case, the Missouri court no doubt supposed that the award was binding by the law of Mississippi. If it was mistaken, it made a natural mistake. The validity of this judgment, even in Mississippi, is, as we believe, the result of the Constitution, as it always has been understood, and is not a matter to arouse the susceptibilities of all states, all of which are equally concerned in the question and equally on both sides. Judgment reversed. We have Justice White, whom concurred, Justice Harlan, and Justice McCann, and Justice Day dissenting. This court now reverses on the ground that the due faith and credit clause obliged the courts of Mississippi, in consequence of the action of the Missouri court, to give efficacy to transactions in Mississippi that were criminal and which were against the public policy of that state. Although not wishing in the slightest degree to weaken the operation of the due faith and credit clause as interpreted and applied from the beginning, it to me seems that this ruling so enlarges that clause as to cause it to obliterate all state lines, since the effect would be to endow each state with authority to overthrow the public policy and criminal statutes of the others, thereby depriving all of their lawful authority. Moreover, the ruling now made, in my opinion, is contrary to the conceptions which caused the due and full faith and credit clause to be placed in the Constitution, and substantially overrules the previous decisions of this court interpreting that clause. My purpose is to briefly state the reasons which lead me to these conclusions. When the Constitution was adopted, the principles of comity by which the decrees of the courts of one state were entitled to be enforced in another were generally known. But the enforcement of those principles by the several states had no absolute sanction, since they rested in comity. Now it can't be denied that under the rules of comity recognized at the time of the adoption of the Constitution, and which at this time universally prevail, no sovereignty was under the slightest moral obligation to give the effect to a judgment of a court of another sovereignty, when to do so would compel the state in which the judgment was sought to be executed to enforce an illegal or prohibited contract, when both the contract and all the acts done in connection with its performance had been placed in the latter state. This seems to me conclusive of this case, since both in trees and authoritative writers, citing Justice Story's Conflict of Laws, Section 609, and by repeated adjudications of this court, it has been settled that The purpose of the due faith and credit clause was not to confer any new power, but simply to make obligatory that duty when the Constitution was adopted, was rested, and has been said in comedy alone. No special reference has been made by me to the arbitration because that is assumed by me to be negligible. If the cause of action was open for inquiry for the purpose of deciding whether the Missouri court had jurisdiction to render a judgment entitled to be enforced in another state, the arbitration is of no consequence. The violation of law in Mississippi could not be cured by seeking to arbitrate in that state in order to fix the sum of the fruits of the illegal acts. The ancient maxims that something cannot be made out of nothing, and that which was void for reasons of public policy cannot be made valid by confirmation or acquiescence seem to my mind decisive. I therefore dissent. All right, everybody. Happy Easter to all. We are now moving on to our next case. We have 3 today. It's going to be a long night. We have the second one is Thomas versus Washington Gas Light Company, a 1980 U.S. Supreme Court case. Oh, it's a doozy. Oh, it keeps going and going. Let's just check out how much we're in for here. We have 2 concurrences, and we have 2 dissenters, and Moses. Okay, we're going to be here for a minute with this one. And the last case tonight will be Baker versus General Motors Corporation, which is also of significant length. All right. Thomas v. Washington Gas Light Company. Justice Stevens announced the judgment of the court and delivered an opinion to which Justice Brennan, Justice Stewart, and Justice Blackmun joined. Petitioner received an award of disability benefits under the Virginia Workmen's Compensation Act. The question presented is whether the obligation of the District of Columbia to give full faith and credit to that award there's a supplemental award under the District Workmen's Compensation Act. Petitioner, who is a District of Columbia resident, was hired by respondent in a district to perform work primarily in the district, but also in Virginia and Maryland. In January of 1971, he sustained a back injury while at work in Arlington, Virginia. Several weeks later, the Virginia Industrial Commission approved the parties' Industrial Commission's of Virginia Memorandum of Agreement to Payment of Compensation, providing for benefits of $62 per week. The Commission issued an award directing that payments continue during incapacity, subject to various contingencies and changes set forth in the Virginia statute. In 1974, petitioner notified the Department of Labor of his intention to seek compensation under the District of Columbia Act. Respondent opposed the claim primarily on the grounds that since, as a matter of Virginia law, the Virginia award excluded any other recovery at common law or otherwise on account of the injury in Virginia, the District of Columbia's obligation to give that award full faith and credit precluded a second supplemental award in the District of Columbia. The administrative law agreed with respondent that the Virginian award must be given res judicata effect in the district to extend that it would be res judicata in Virginia. He held, however, that the Virginia award by its terms did not preclude a further award of compensation in Virginia. Moreover, he construed the statutory prohibition against additional recovery at common law or otherwise as merely covering common law and other remedies under Virginia law. After the taking of medical evidence, the petitioner was awarded permanent total disability benefits payable from the date of his injury with a credit for the amounts previously paid under a Virginia award. The Benefits Review Board upheld the award. Its order, however, was reversed by United States Court of Appeals of the Fourth Circuit, which squarely held that a second and separate proceeding in another jurisdiction upon the same injury after a prior recovery in another state is precluded by a full faith and credit clause. We grant certiorari and now reverse. 1. Respondent contends that the District of Columbia was without power to award petitioner additional compensation because of the full faith and credit clause of the Constitution, or more precisely, because of the full federal statute implementing that clause. An analysis of this contention must begin with 2 decisions from the 1940s that are almost directly on point: Magnolia Petroleum Company versus Hunt and Industrial Commission of Wisconsin versus McCartan. In Magnolia, a case relied heavily on both the respondent and the Court of Appeals. The employee hired a Louisiana worker in Louisiana. The employee was later injured during the course of his employment in Texas. A tenuous majority held that Louisiana was not permitted to award the injured worker supplementary compensation under the Louisiana Act after he'd already obtained a recovery from the Texas Industrial Accident Board. Quote, respondent was free to pursue his remedy in either state, but having chosen to seek it in Texas, where the award was res judicata, the full faith and credit clause precludes him from again seeking a remedy in Louisiana upon the same grounds. Little more than 3 years later, the court severely curtailed the impact of Magnolia in McCartan. The employer and the worker both resided in Illinois and entered into an employment contract there for work performed in Wisconsin. The employee was injured in the course of that employment. He initially filed a claim with the Industrial Commission of Wisconsin. Prior to the court's decision in Magnolia, the Wisconsin Commission informed him that under Wisconsin law, he could proceed under the Illinois Workmen's Compensation Act and then claim compensation under the Wisconsin Act with credit to be given for any payments made under the Illinois Act. Thereafter, the employer and the employee executed a contract for payment of a specified sum in full settlement of the employer's right under Illinois law. The contract expressly provided, however, that it would, quote, not affect any rights that the applicant may have under the Workmen's Compensation Act in the state of Wisconsin, close quote. The employee then obtained a supplemental award under Wisconsin Industrial Commission, but the Wisconsin state courts vacated it under felt compulsion from intervening decision in Magnolia. This court reversed, holding that without dissent, that Magnolia was not controlling. Although the court could have relied exclusively on the contract provision reserving the employer's rights under Wisconsin law to distinguish the case of Magnolia, Justice Murphy's opinion provided a significantly different ground for the court's holding when it said, quote, this reservation spells out why we believe to be implicit in the Illinois Workers' Compensation Act, namely that an award of the type here involved does not foreclose on an additional award under the laws of another state, and in settling of this case, that fact is of decisive significance. Earlier in that opinion, the court had stated, quote, only some unmistakable language by a state's legislatures or judiciary would warrant our accepting a construction that workers' compensation statute is designed to preclude any recovery by proceedings brought in another state, end quote. The Illinois statute, which the court had held not to contain the unmistakable language, required to preclude a supplemental award in Wisconsin broadly provided, open quote, no common law or statutory right to recover damages for injury or death sustained by an employee while engaged in the line of his duty at such employee other than the compensation herein provided shall be available to any employee who is covered by the provisions of this act, end quote. The Virginia Workers' Compensation Act exclusively remedy provision is not exactly the same as Illinois', but it contains no, quote, unmistakable language, end quote, directed at precluding a supplemental compensation award in another state that was not also in the Illinois Act. Consequently, McCartan, by its terms, rather than the earlier Magnolia decision, is controlling as between the two precedents. Nevertheless, the fact that we find ourselves comparing the language of two state statutes, neither of which has been construed by the highest court of either state, in an attempt to resolve an issue arising under the full faith and credit clause, makes us pause to inquire whether there is a fundamental flaw in our analysis of this federal question. Section 2. We cannot fail to observe that in the court's haste to retreat from Magnolia, it fashioned a rule that clashes with normally accepted full faith and credit principles. It has long been the law that the judgment of a state court should have the same credit, validity, and effect in every other court in the United States, which it had in the court where it was pronounced. This rule, if not compelled by the full faith and credit clause itself, is surely required by 28 U.S.C. 1738, which provide that the, quote, acts, recordings, and judicial proceedings of any state shall have the same full faith and credit in every court within the United States as they have by law or usage in the courts of the state from which they are taken, end quote. Thus, in effect, by virtue of the full faith and credit obligations of the several states, a state is permitted to determine the extraterritorial effect of its judgment, but it may only do so indirectly by prescribing the effects of its judgment within the state. The McCartan rule, however, focusing as it does on the extraterritorial intent of the rendering state, is fundamentally different. It authorizes a state by drafting or construing its legislation in unmistakable language directly to determine the extraterritorial effect of its workers' compensation awards. An authorization to a state legislature of this character is inconsistent with a rule established in Pacific Employees Insurance Company versus Industrial Accident Commission, discussed at page 288 Supra. Quote, this court must determine for itself how far the full faith and credit clause compels the qualification or denial of rights asserted under the laws of one state than that of the form of the statute in another state. it follows inescapably that the McCartan's unmistakable language rule represents an unwarranted delegation to the states of this court's responsibility for the final arbitration of full faith and credit questions. The full faith and credit clause, quote, is one of the provisions incorporated into the Constitution by its framers for the purpose of transforming an aggregation of independent sovereign states into a nation. To vest the powers of determining this extraterritorial effect of a state's own laws and judgments in the state itself risks the very kind of parochial entrenchment on the interests of other states that it was the purpose of the full faith and credit clause and other provisions of Article 4 of the Constitution to prevent. Thus, a re-examination of McCarran's unmistakable language test reinforces our tentative conclusion that it does not provide an acceptable basis on which to distinguish Magnolia. But if we reject that test, we must decide whether to overrule either Magnolia or McCarran. In making this kind of decision, we must take into account both the practical value served by the doctrine of stare decisis and the principles that inform the full faith and credit clause. 3. The doctrine of stare decisis imposes a severe burden on the litigant who asks us to disavow one of our precedents. For that doctrine not only plays an important role in orderly adjudication, it also serves the broader societal interest in even-handed, consistent, and predictable application of legal rules. When rights have been created or modified in reliance on established rules of law, the arguments against their change have special force. It is therefore appropriate to begin the inquiry by considering whether a rule that permits or a rule that forecloses successive workers' compensation awards is more consistent with settled practice. The answer to this question is pellucidly clear. It should first be noted that Magnolia, by only the slightest majority, effected a dramatic change in the law that had previously prevailed throughout the United States. Of greater importance is the fact that, as a practical matter, the unmistakable language rule of construction announced in McCartan left only the narrowest areas in which Magnolia could have had any further precedential value. For the exclusively language in the Illinois class construed in McCartan was typical of most state workers' compensation laws. Consequently, it was immediately recognized that Magnolia no longer had any significant practical impact. Moreover, since the state legislature seldom focuses on the extraterritorial effect of its enactments, and since the state court had even less occasion to consider why an award under its state's law is intended to preclude a supplementary award under another state's Workmen's Compensation Act, the probability that any state would thereafter announce a new rule against supplemental awards in other states was extremely remote. As a matter of fact, subsequent cases in the state courts have overwhelmingly followed McCartan and permitted successive state workers' compensation awards. Thus, all that really remained of Magnolia after McCarran was a largely theoretical difference between what the court described as unmistakable language and the broad language of the exclusive remedy provision of the Illinois Workers' Compensation Act that was involved in McCartan. This whole history indicates that the principal values underlying the doctrine of stare decisis would not be served either by attempting to revive Magnolia or by attempting to preserve the unnecessary coexistence of Magnolia or McCartan. The latter attempt could only breed uncertainty and unpredictability, since the application of the unmistakable language rule of McCarran necessarily depends upon a determination by one state tribunal of the effect to be given the statutory language enacted by the legislature of a different state. And the former would represent a rather dramatic change that surely would not promote stability in the law. Moreover, since Magnolia has been so rarely followed, there appears little danger that there has been any significant reliance on its rule. We conclude that a fresh examination of the full faith and credit issue is therefore entirely appropriate. 4. 3 different state interests are affected by the potential conflict between Virginia and the District of Columbia. Virginia has a valid interest in placing a limit on the potential liability of companies that transact business within its borders. Both jurisdictions have a valid interest in the welfare of the injured employee. Virginia, because the injury occurred within its state, and the district because the injured party was employed and resided there. And finally, Virginia has an interest in having the integrity of its formal determinations of contested issues respected by other sovereign states. The conflict between the first 2 interests was resolved in Alaska Packers Association versus Industrial Accident Commission and a series of later cases. It is perfectly clear that the petitioner could have sought a compensation award in the first instance, either in Virginia, the state in which the injury occurred, or in the District of Columbia where the petitioner resided. His employer was principally based in the employment relation was formed in the District of Columbia as well, and as those cases underscore, compensation would have been sought under either compensation scheme if one statute or the other purported to confer an exclusive remedy on the petitioner. Thus, for all practical purposes, respondent and its insurer would have to measure their potential liability exposure by the more generous of the two workmen's compensation schemes in any event. It follows that a state's interest in limiting the potential liability of businesses within the state is not of controlling importance. It also is manifest that the interest in providing adequate compensation to the injured worker would be fully served by the allowance of successive awards. In this respect, the two jurisdictions share a common interest, and there is no danger of significant conflict. The ultimate issue, therefore, is whether Virginia's interest in the integrity of its tribunal's determination forecloses a second proceeding to obtain a supplemental award in the District of Columbia. We return to the court's prior resolution of the question in Magnolia. The Magnolia majority opinion took the position that the case called for a straightforward application of the full faith and credit law. The worker's injury gave rise to a cause of action. Relief was granted by the Texas Industrial Accident Board. That award precluded any further relief in Texas, and further relief was therefore precluded elsewhere as well. The majority relied heavily on Chicago RI and PR versus Schneidel for the proposition that a workman's compensation award stands on the same footing as a court judgment, and that a compensation award under one state's law is a bar to a second award under another state's law. But Schendel did not compel the result in Magnolia. In Schendel, the court held that an Iowa state compensation award, which is grounded in a contested factual finding that the deceased railroad employee was engaged in interstate commerce, precluded the subsequent claim under the Federal Employees Liability Act brought in the Minnesota State Court, which would have required a finding that the employee was engaged in interstate commerce. Schendel, therefore, involved the unexceptionable full faith and credit principle that resolutions of factual matters underlying a judgment must be given the same res judicata effect in the forum state as they have in the rendering state. The Minnesota courts could not have granted relief under the FELA and also respected the factual findings made in Iowa, because the facts differ in those cases, right? In contrast, neither Magnolia nor this case concerns a second state's contrary resolution of a factual matter determined in the first state's proceedings. Unlike the situation in Schendel, which involved two mutually exclusive remedies, compensation could have been obtained under either Virginia or the district's workmen's compensation statutes on the basis of the same set of facts. A supplemental award gives full effect to the facts determined by the first and also allows full credit for payments pursued to the earlier award. There is neither inconsistency nor double recovery. We are also persuaded that Magnolia's reliance on Schendel for the proposition that workmen's compensation awards stand on the same footing as court judgments is unwarranted. To be sure, as we held in Schendel, the fact findings of state administrative tribunals are entitled to the same res judicata effect in the second state as findings of a court. But the critical difference between a court of general jurisdiction and an administrative agency with limited statutory authority forecloses the conclusion that constitutional rules applicable to court judgments are necessarily applicable to workmen's compensation awards. A final judgment entered by a court of general jurisdiction normally establishes not only the measure of the plaintiff's rights, but also limits the defendant's liability. A traditional application of res judicata principles enables either party to claim the benefit of the judgment insofar as it resolved issues the court had jurisdiction to decide. Although a Virginia court is free to recognize and perhaps paramount interest of another state by choosing to apply that state's law in a particular case, the Industrial Commission of Virginia does not have that power. Its jurisdiction is limited to questions arising under Virginia's Workmen's Compensation Act. Typically, a workmen's compensation tribunal may only apply its own state law. In this case, the Virginia Commission could and did establish the full measure of petitioner's rights under Virginia law, but it neither could nor purported to determine his rights under the law of the District of Columbia. Full faith and credit must be given to the determination that the Virginia Commission had the authority to make, but by a parity of reasoning, full faith and credit need not be given to determinations that it had no power to make. Since it was not requested and had no authority to pass on petitioner's rights under the District of Columbia law, there can be no constitutional objection to fresh adjudications of those rights. It is true, of course, that after Virginia entered its award, that state had an interest in preserving the integrity of that which it had done, and that is squarely within the purpose of the full faith and credit clause, as explained in Pacific Employers. Quote, to preserve rights acquired or confirmed under the public acts of Virginia by requiring the other states to recognize their validity. Thus, Virginia had an interest in having respondent pay petitioner the amount specified in its award. Allowing a supplementary recovery in the district does not conflict with that interest. As we've already noted, Virginia also has a separate interest in placing a ceiling on the potential liability of companies that transact business within its borders. But past cases have established that that interest is not strong enough to prevent other states from overlapping jurisdictions over particular injuries from giving their effect to the more generous compensation policies when the employee selects the most favorable form in the first instance. That's a hell of a sentence. Thus, the only situations in which Magnolia rule would tend to serve that interest are those in which an injured workman has either been constrained by circumstances to seek relief in a less generous form or has simply made an ill-advised choice of his first form. But in neither of those cases is there any reason to give extra credit to the first state's interest in placing a ceiling on the employer's liability than otherwise would have had. For neither the first nor second state has any overriding interest in requiring an injured employee to proceed with special caution when first asserting his claim. Compensation proceedings are often initiated informally and without the advice of counsel and without special attention to the choice of the most appropriate form. Often the worker is hospitalized when benefits are sought, as was true in this case. And indeed, it is not always the injured worker who institutes the claim. This informality is consistent with the interests of both states. A rule forbidding supplemental recoveries under more favorable workmen's compensation schemes would require a far more formal and careful choice on the part of the injured worker that may be possible or desirable when immediate commencement of the benefits may be essential. Thus, whether or not the worker has sought an award from the less generous jurisdiction in the first instance, the vindication of that state's interest in placing a ceiling on employer's liability would inevitably impinge upon the substantial interest of the second jurisdiction in the welfare of the subsistences of disabled workers. Interest in that a court of general jurisdiction might consider, but which must be ignored by the Virginia Industrial Commission. The reasons why the statutory policy of exclusivity of other jurisdictions involved in Elastic Packers and Pacific Employers, SUPRA, could not defeat California's implementation of its own compensation policies, therefore continue to apply even after the entry of a workman's compensation award. Of course, it is for each state to formulate its own policy whether to grant supplemental awards according to its perception of its own interests. We simply conclude that the substantial interest of the second state in these circumstances should not be overridden by another state through an unnecessarily aggressive application of the full faith and credit clause, as was implicitly recognized at the time of McCartan. We therefore hold that a state has no legitimate interest within the context of our federal system in preventing another state from granting a supplemental compensation award when the second state would have had the power to apply its workers' compensation law in the first instance. The full faith and credit clause should not be construed to preclude successive workers' compensation awards. Accordingly, Magnolia Petroleum Company versus Hunt should be overruled. The judgment of the Court of Appeals is reversed. All right. Now we have a concurrence. Justice White, with whom the Chief Justice and Justice Powell join concurring in the judgment, but not the reasoning. I agree that the judgment of the Court of Appeals should be reversed, but I am unable to join in the reasoning by which the plurality reaches that result. Although plurality argues strenuously that the rule of today's decision is limited to awards by state workers' compensation boards, it seems to me that the underlying rationale goes much farther. If the employer had exercised its statutory right of appeal to the Supreme Court of Virginia and that court upheld the award, I presume that the plaintiff's rationale would nevertheless permit a subsequent award in the District of Columbia. Otherwise, the employer's interest in cutting off the possibility of subsequent award in another jurisdiction need only seek judicial review of the award in the first forum. But if such a jurisdictional or judicial decision, is not preclusive in the second forum, then it appears that plurality's rationale is not limited in its effect to judgments of administrative tribunals. The plurality contends that unlike courts of general jurisdiction, workmen's compensation tribunals generally have no power to apply the law of another state and thus cannot determine the rights of the parties thereunder. Yet I see no reason why a judgment should not be entitled to full res judicata effect under the full faith and credit clause merely because the rendering tribunal was obligated to apply the law of the forum state, provided, of course, as was certainly the case here, that the forum could constitutionally apply its own law. The plurality's analysis seems to grant state legislatures the power to delimit the scope of cause of an action for a full faith and credit claim purpose merely by enacting a choice of law rules binding on that state's workers' compensation tribunals. The plurality criticizes the McCartan case for vesting in the state the power to determine the extraterritorial effects of its own laws and judgments. Yet it seems that this opinion is subject to the same objection. In any event, I am not convinced that Virginia, by instructing its industrial companies to apply Virginia law, could be said to have intended that the cause of action which emerges in Virginia judgment would not include claims under the laws of other states which arise out of precisely the same operative facts. As a matter of logic, the pluralities analysis would seemingly apply to many everyday tort actions. I see no difference for full faith and credit purposes between a statute which lays down a form favoring choice of law rule and a common law doctrine stating the same principle. Hence, when a court having power in the abstract to apply the law of another state determines by application of the forum's choice of law rules to apply the substantive law of the forum, I would think that under the pluralities analysis, the judgment would not determine rights arising under the law of some other state. Suppose, for example, that in a wrongful death action, the court enters judgment on liability against the defendant and determines to apply the law of the forum state, which sets a limit on the recovery allowed. The pluralities analysis would seem to permit the plaintiff to obtain a subsequent judgment in a second forum for damages which exceed the forum state's liability limit. The plurality does say that factual determinations by a workers' compensation board will be entitled to collateral estoppel effect in the second forum. While that rule does, to an extent, circumscribe the broadest possible implications of the plurality's reasoning, there would remain many cases, such as the wrongful death example discussed above, in which the second forum could provide additional recovery as a matter of substantive law while remaining true to the first forum's factual determinations. Moreover, the dispositive issues in tort actions are frequently mixed questions of law and fact as to which the second forum might apply its own rule of decision without obvious violation of the principle articulated by the members of the court, the four of them today. Actions by the defendant which satisfy the relevant standard of care in the first forum might nevertheless be considered negligent under the law of the second forum. Hence, the plurality's rationale would portend a wide-ranging reassessment of the principles of full faith and credit in many areas. Such a reassessment is not necessarily undesirable if the results are likely to be healthy for the judicial system and consistent with the underlying purposes of the full faith and credit clause. But at least without the benefit of briefs and arguments directed to that issue, I cannot conclude that the rule advocated by the plurality would have had such a beneficial impact. One purpose of the full faith and credit clause is to bring an end to litigation, as the court noted in Riley v. New York Trust Company in 1941. Quote, were it not for this full faith and credit provision, as far as the Constitution controls the matter, adversaries could wage again their legal battles wherever they meet in other jurisdictions. Each state could control its own courts, but itself could not protect the effects of its decisions beyond its own boundaries. End quote. The plurality's opinion is at odds with this principle of finality. Plaintiffs dissatisfied with a judgment would have every incentive to seek out additional recovery elsewhere, so long as the first forum applied its own law and there was a colorable argument as the matter of law in the second forum would permit a greater recovery. It seems to me grossly unfair that the plaintiff, having the initial choice of forum, should be given the additional advantage of a second adjudication should his choice prove disappointing. Defendants, on the other hand, would no longer be assured that the judgment of the first forum is conclusive as to their obligations and would face the prospect of burdensome and multiple litigation based on the same operative facts. Such litigation was also imposed added strain on our already overworked judicial system. Perhaps the major purpose of the full faith and credit clause is to act as a nationally unifying force. The plurality's rationale would substantially undercut this function. When a form of judgment is set up as a defense made under the full faith and credit clause, the court will be obliged to balance the various state interests that are involved. But the state of the second form is not a neutral party to this balance. There seems to be a substantial danger not presented by the firmer rule of res judicata that the court, in evaluating a full faith and credit defense, would give controlling weight to its own parochial interest in concluding that the judgment of the first form was not res judicata in the subsequent suit. I would not overrule either Magnolia or McCarran. To my mind, Chief Justice Stone's opinion in Magnolia states the sounder doctrine. As I noted, I do not see any overriding differences between the workmen's compensation awards and court judgments that justify a different treatment for the two. However, McCarran has been on the books for over 30 years and has been widely interpreted by state and federal courts as a substantially limiting Magnolia. Unlike the plurality's opinion, McCarran has not subject to the objection that its principles are applicable outside the workers' compensation area. While I find that McCarran to rest on the question of questionable foundations, I am not now prepared to overrule it. And I agree with the plurality that McCartan rather than Magnolia is controlling as between the precedents set by the Virginia's Workmen's Compensation Act, and that lacks the unmistakable language which McCarran requires for a workers' compensation award is to preclude a subsequent award in another state. I therefore concur in judgment. Now we have two dissents. we have Justice Rehnquist and Justice Marshall. Oh, Rehnquist wrote the opinion, Marshall is joining. This is clearly a case where the whole is less than the sum of its parts. In choosing between two admittedly inconsistent precedents, Magnolia and McCartan, 6 of us agreed that McCartan is analytically indefensible. The remaining 3 members of this court concede that it rests on questionable foundations. Nevertheless, when the smoke clears, it is Magnolia rather than McCartan that the plurality suggests should be overruled. I believe that Magnolia was correctly decided, and because I fear that this rule proposed by the plurality is both ill-considered and ill-defined, I dissent. One might support that, having destroyed McCartan's ratio decidenti, the plurality would return to the eminently defensible position adopted in Magnolia. But such is not the case. The plurality instead raises the banner of stare decisis and sets out in search of a new rationale to support the result reached in McCartan, significantly failing to even attempt to do the same thing for Magnolia. Such a post hoc rationalization seems a bit odd. The theory ultimately chosen by the plurality is even odder. It would seem that, contrary to the assumption of this court for at least the past 40 years, a judgment awarding workers' compensation benefits is no longer entitled to full faith and credit unless, and only to the extent that, such a judgment resolves the disputed issue of fact. I believe that plurality's justification for such a theory, which apparently first surfaced in a cluster of articles written in the wake of Magnolia, does not withstand close scrutiny. The plurality identified 3 different state interests at stake in the present case. Virginia's interest in placing a limit on the potential liability of companies doing business in that state, Virginia's interest in the integrity of its formal determinations of contested issues, and a shared interest in Virginia and the District of Columbia in the welfare of the injured employee. The plurality then undertakes to balance these interests and concludes that none of Virginia's concerns outweighs the concerns of the District of Columbia for the welfare of the petitioner. Whatever this court or any court attempts to balance competing interests, it risks undervaluing or even overlooking important concerns. I believe that the plurality's analysis incorporates both errors. First, it asserts that in Virginia's interest in limiting the liability of businesses operating within its borders can never outweigh the District of Columbia's interest in protecting its residents. In support of this proposition, it cites Alaska Packers and Pacific employees. Both of those cases, however, involve the degree of faith and credit to be afforded statutes of one state by the courts of another state. The present case involves an enforceable judgment entered by Virginia after adjudicating proceedings. In Magnolia, Mr. Chief Justice Stone, who authored both Alaska Packers and Pacific employers, distinguished those 2 decisions for precisely this reason, chastising the lower court in that case for overlooking, quote, the distinction long recognized and applied by this quote between the full faith and credit required to be given a judgment and that which local and common statutory law is entitled under the Constitution and laws of the United States, end quote. This distinction, which has also been overlooked by the plurality here, makes perfect sense, since Virginia surely has a stronger interest in limiting an employer's liability to a fixed amount when that employer has already been hailed before a Virginia tribunal and adjudicated liable than when the employer simply claims the benefit of a Virginia statute is proceeding brought in another state. In a similar vein, the plurality completely ignores any interest that Virginia might assert in the finality of its adjudications. While workmen's compensation awards may be non-final in the sense that they are subject to continuing supervision and modification, Virginia nevertheless has a cognizable interest in requiring persons who avail themselves of its statutory remedy to eschew other alternative remedies which might be available to them. Otherwise, as apparently is the result here, Virginia's efforts and expense on the applicant's behalf are wasted when the applicant obtains a duplicative remedy in another state. At base, the plurality's balancing analysis is incorrect because it recognizes those that would have transpired had petitioner initially sought his remedy in the District of Columbia. But there are differences. The Commonwealth of Virginia has expended its resources at petitioner's behest to provide the petitioner with a remedy for his injury and a resolution of his dispute with his employer. That employer similarly has expended its resources, again at the petitioner's behest, in complying with a judgment entered by Virginia. These efforts and the corresponding interest in seeing that those efforts are not wasted lie at the very heart of the divergent constitutional treatment of judgments and statutes. In this case, of course, Virginia and respondent expended very few resources in the administrative process. But that observation lends no assistance to the plurality, which would flatly hold that Virginia has absolutely no power to guarantee that a workman's compensation award will be treated as a final judgment by any other state. In further support of its novel rule, the plurality attempts to distinguish the judgment entered in this case from one entered by, quote, a court of general jurisdiction, end quote. Specifically, the plurality points out that in the Industrial Commission of Virginia, unlike a state court of general jurisdiction, was limited by the statute to consider the Virginia law. According to the plurality, because the commission, quote, was not requested and had no authority to pass on the petitioner's rights, under District of Columbia law, there can be no constitutional objection to a fresh adjudication of those rights, end quote. This argument might have some force if petitioner had somehow had Virginia law thrust upon him against his will. In this case, however, petitioner was free to choose the applicable law simply by choosing the form in which he filed his initial claim. Unless the District of Columbia has an interest in forcing its residents to accept its law regardless of their wishes, I fail to see how the Virginia Commission's inability to look to the District of Columbia law impinged upon the latter's jurisdictional interests. I thus fail to see why the petitioner's election as consummated in his Virginia award should not be given the same full faith and credit as would have been afforded a judgment entered by a court of general jurisdiction. I suspect that my brethren's insistence on ratifying the Carton result, despite condemnation of its rationale, is grounded in no small part upon their concern that injured workers are often coerced or maneuvered into filing their claims in jurisdictions amenable to their employers. This is, however, absolutely no evidence of such overreaching in the present case. Indeed, had there been fraud, imposition, or mistake in the filing of petitioner's claim, he would have been permitted, upon timely motion, to vacate the award. See Harris versus Diamond Construction Company, 1946 case. In this regard, the award received by petitioner is treated no differently than any other judicial award, and it should not be. I fear that the plurality, in its zeal to remedy a perceived imbalance in bargaining power, would badly distort an important constitutional tenet. It's the interest analysis, once removed from the statutory choice of law context considered by the court in Alaska Packers and Pacific Employers, now or knows no meters or bounds. Given the modern proliferation of quasi-judicial methods for resolving disputes in various tribunals of limited jurisdiction, such a rule could only lead to confusion. I find such uncertainty unacceptable and prefer the rule originally announced in Magnolia, a rule whose analytical validity is even yet unchallenged. The full faith and credit clause did not allot to this court the task of balancing the interests where the public acts records and judicial proceedings of the state were involved. It simply directed that they be given full faith and credit. That the court today denies those of Virginia. I would affirm the judgment of the courts below. Well, that was a hell of a case. All right. We're going to move to the last case for today, which is Baker versus General Motors Corporation, a 1998 case. Ruth Bader Ginsburg delivers the opinion of the court. We have Ginsburg's opinion. Goes on and on. And then Justice Scalia concurs in the judgment, but not the rationale. Justice Kennedy, with whom O'Connor and Thomas join, concurs in the judgment, but for different reasons than Scalia does. And there's no dissent. Okay. So it's a 98 case, U.S. Supreme Court. So Ronald Elwell worked for the engineering analysis group of General Motors Corporation from 59 to 89. During this time, he often aided GM lawyers in defending GM against product liability actions. Between 87 and 91, the Elwell-GM employment relationship soured, resulting in failed negotiations of the terms of Elwell's retirement. In May of 91, Elwell appeared as a witness for plaintiffs in a product liability action against GM in Georgia and testified that the GM pickup truck fuel systems were inferior to competing products. The next month, Elwell sued GM in a Michigan state court alleging a wrongful discharge and other tort actions and contract claims. GM counterclaimed contending that Elwell had breached his fiduciary duty to GM by disclosing privileged and confidential information and misappropriating documents. In August 92, the parties entered into a settlement agreement. Elwell received an undisclosed sum of money and agreed the Michigan court's entry of a permanent injunction preventing him from disclosing GM's trade secrets and other confidential information, or from, quote, testifying without the prior written consent of any General Motors Corporation, either upon deposition or at trial as an expert witness or as a witness of any kind, and from consulting with attorneys or their agents in any litigation already filed or be filed in the future involving General Motors as an owner, seller, manufacturer and or designer of the products at issue, end quote. The injunction contained an exception that stated, open quote, this provision shall not operate to interfere with the jurisdiction of the court in Georgia, where the litigation involving the bad fuel tanks was still pending. This injunction contained no other limitation but a separate settlement agreement between the parties provided, quote, it is agreed that Elwell's appearance and testimony, if any, at the hearings on the motions to quash or subpoena, a deposition or trial or other official proceeding, if the court or any other tribunal so orders, will in no way form a basis for the action of violation of the permanent injunction or of this agreement, end quote. In the 6 years since the Elwell GM settlement, Elwell testified against GM both in Georgia and in several other jurisdictions in which Elwell has been subpoenaed to testify. Meanwhile, in 1991 September, Kenneth and Stephen Baker sued GM in Missouri State Court to recover for the death of their mother in a highway accident in Missouri on a Chevrolet S10 Blazer. After GM removed the case to federal court, the Bakers subpoenaed Elwell. GM objected to Elwell's appearance as a deponent or trial witness on the grounds that the Michigan injunction barred his testimony. The district court allowed the Bakers to depose Elwell and to call him as a witness at trial on the grounds that, one, blocking Elwell's testimony pursuant to the Michigan injunction would violate Missouri's public policy, and two, because the Michigan court could modify the Michigan injunction, so too could a Missouri federal court. Following GM's appeal from an $11.3 million jury award, the U.S. Court of Appeals for the Eighth Circuit reversed on the ground that Elwell's testimony should not have been admitted. The court reasoned that the trial court erroneously relied on a Missouri policy favoring disclosure of relevant, non-privileged information because of Missouri's equally strong public policy in favor of full faith and credit. The Eighth Circuit also noted that the Michigan court, quote, has been asked on several occasions to modify the injunction but has not yet done so, end quote, and noted that if the Michigan court did not intend to block Elwell's testimony in cases like the Bakers, the injunction would have been unnecessary in the first place. The Supreme Court granted certiorari to decide whether the full faith and credit requirement stops the Bakers, who are not parties to the Michigan proceeding, from obtaining Elwell's testimony in the Missouri wrongful death action. 2A. Our full faith and credit clause precedent differentiates the credit owed to laws and to judgments. In numerous cases, this court has held that the credit must be given to the judgment of another state, although this form that would not be required to entertain the suit on which the judgment was founded. The full faith and credit clause does not compel a state to substitute the statutes of other states for its own statutes dealing with a subject matter concerning which it is competent to legislate. Regarding judgments, however, the full faith and credit clause obligation is exacting. A final judgment in one state, if rendered by a court with adjudicatory authority over the subject matter and persons governed by the judgment, qualifies for recognition throughout the land. For claim and issue preclusion, res judicata purposes, in other words, the judgment of the rendering state gains nationwide force. A court may be guided by the forum state's public policy in determining the law applicable to a controversy, but our decisions support no revolving public policy obsession to the full faith and credit due judgments. What? Oh, in assuming the existence of an ubiquitous public policy exception permitting one state to resist the recognition of another state's judgment, the district court in the Baker's wrongful death action misread our precedent. The full faith and credit clause is one of the provisions incorporated into the Constitution by its framers for the purpose of transforming an aggregation of independent sovereign states into a nation. We are aware of no considerations of local policy or law which could rightly be deemed to impair the force and effect which a full faith and credit clause in the act of Congress required to be given a money judgment from outside the state of its rendition. The court has never placed equity decrees outside of the full faith and credit domain. Equity decrees for non-payment of money have long been considered equivalent to judgments at law entitled to nationwide recognition. We see no reason why the preclusive effects of an adjudication on parties or those in privity with them, i.e. claim preclusion and issue preclusion, res judicata and collateral estoppel, should differ depending solely upon the type of relief sought in a civil action. Full faith and credit, however, does not mean that states must adopt the practices of other states regarding the time, manner, and mechanisms for enforcing judgments. Enforcement measures do not travel with the sister state's judgment as preclusive effects do. Such measures remain subject to the even-handed control of the forum law. Orders commanding action or inaction have been denied enforcement in a sister state when they purported to accomplish an official act within the exclusive province of that other state or interfere with the litigation over which the ordering state has no authority. Thus, a sister state's decree concerning land ownership in another state has been held ineffective to the transfer of title. Anti-suit injunctions regarding litigation elsewhere, even if compatible with due process as a direction constraining parties to the decree, in fact, have not controlled the second court's actions regarding litigation in that court. Sanctions for violations of an injunction in any event are generally administered by the court that issued the injunction, not the court that overruled it. B. With these background principles in view, we turn to the dimensions of the order GM relies upon to stop Elwell's testimony. Specifically, we take up the question, what matters did the Michigan injunction legitimately conclude? As earlier recounted, the parties before the Michigan County Court, Elwell and GM, submitted an agreed-upon injunction, which the presiding judge signed, which no issue was joined, expressly litigated, and determined in the Michigan proceeding. That order is claim preclusive between Elwell and GM's claim for wrongful discharge and his related contract, and the tort's claims have, quote, merged in their judgment, and he cannot sue again to recover more. Similarly, GM cannot sue Elwell elsewhere on the counterclaim that GM asserted in Michigan. Michigan's judgment, however, cannot reach beyond the Elwell-GM controversy to a control proceedings against GM brought by sister states by other parties asserting claims at the merits of which Michigan was not considered. Michigan has no power over those parties and no basis for commanding them to become interveners in the Elwell-GM dispute. Most essentially, Michigan lacks authority to control courts elsewhere by precluding them in actions brought by strangers to the Michigan litigation from determining for themselves what witnesses are competent to testify, what evidence is relevant, and what evidence is admissible for the truth. As a district court recognized, Michigan's decree could operate against Elwell to preclude him from volunteering his testimony, but a Michigan court cannot, by entering an injunction to which Elwell and GM stipulated, dictate to another court in another jurisdiction that evidence relevant in the Baker's case, a controversy which Michigan is foreign, shall be inadmissible. This conclusion creates no general exception to the full faith and credit command, and surely does not permit a state to refuse to honor a sister state's judgment based on the forum state's choice of law or policy preferences. Rather, we simply recognize that, just as the mechanisms for enforcing a judgment not to travel with the judgment itself for purposes of full faith and credit, just as one state's judgment cannot automatically transfer title of land in another state. Similarly, the Michigan decree cannot determine evidentiary issues in a lawsuit brought by parties who are not subject to the jurisdiction in the Michigan court. The language of the consent decree is informative in this regard. Excluding the then pending Georgia action from the ban of testimony by Elwell without Jim's permission, the decree provides that, quote, shall not operate to interfere with the jurisdiction in the court of Georgia, end quote. But if the Michigan order extended to the Georgia case would have interfered with the jurisdiction of the Georgia court, Michigan's ban would also in the same way interfere with the jurisdiction of courts in any other state in cases similar to the one pending in Georgia. In line with its recognition of the interference potential of the consent decree, GM provided in the settlement agreement that if another court ordered Elwell to testify, his testimony would, open quote, in no way, end quote, render him vulnerable to suit in the Michigan for violating the injunction or agreement. The Eighth Circuit regarded the state settlement agreement provisions as merely a concession by GM that some courts might fail to extend full faith and credit to the Michigan injunction. As we have explained, however, Michigan's power does not reach into a Missouri courtroom to displace the forum's own determination whether to admit or exclude evidence relevant to the Baker's wrongful death case before it. In that light, we see no altruism in GM's agreement, nor to institute contempt or breach of contract proceedings against Elwell in Michigan for giving subpoenaed testimony elsewhere. Rather, we find it telling that GM ruled out resort to the court that entered the injunction, for injunctions are ordinarily enforced by the enjoining court, not a surrogate tribunal. In sum, Michigan has no authority to shield a witness from another jurisdiction's subpoena power in a case involving persons and cases outside of Michigan's governance. Recognition under the full faith and credit is owed to the dispositions Michigan has authority to order, but a Michigan decree cannot command obedience elsewhere on a matter that Michigan courts lack authority to resolve. There you go. Now, Scalia's concurrence in the judgment, but not the reasoning, I guess. All right. Scalia. I agree with the court that enforcement measures do not travel with sister state judgments as preclusive effects do. It has long been established that the judgment of a state court cannot be enforced out of the state by an exertion or by an execution issued within it. To recite that principle is to decide the case. General Motors asked a district court in Missouri to enforce a Michigan injunction. The Missouri court was no more obliged to enforce the Michigan injunction by preventing Elwell from presenting his testimony than it was obliged to enforce it by holding Elwell in contempt. The full faith and credit clause did not make the judgments of other states domestic judgments to all interests and purposes, but only gave a general validity, faith, and credit to them as evidence. No execution can issue upon such judgment without a new suit in the tribunals of other states. A judgment or decree of one state, to be sure, may be grounds for an action or defense to one in another, but the clause in its implementing statute, open quote, establish a rule of evidence rather than a jurisdiction. Will they make the record of a judgment rendered after due notice in one state conclusive evidence in the courts of another state or of the United States of the matters adjudicated, they do not affect the jurisdiction either of the court in which the judgment is rendered or of the court in which it is offered as evidence. Judgments recovered in one state of the Union when proved in the courts of another government, whether state or national within the United States, differ from judgments recovered in a foreign country in no other respect than not being re-examinable on the merits, nor impeachable for fraud of obtaining them, if rendered by a court having jurisdiction over the cause and the parties. That's quoting from Wisconsin versus Pelicans Insurance Company, 1888 case. The judgment that General Motors obtained in Michigan does not carry with it into another state the efficacy of a judgment upon property or persons to be enforced by execution. To give it the force of a judgment in another state, it must be made a judgment there, and can only be executed in the latter as its laws may permit. A case involving a suit to obtain an equity decree ordering the conveyance of land, duplicating such a decree already issued in another state would be unenforceable, because neither the full faith and credit clause nor its implementing statute requires a Missouri court to execute the injunction issued by the courts of Michigan. I concur in the judgment. And as part of his concurrence is admitted because our editors don't want to give us full answers to stuff, but whatever. Then we have Justice Kennedy, the romantic poet, with whom O'Connor and Thomas concurring in the judgment. I concur in the judgment. In my view, the case is controlled by well-settled full faith and credit principles, which render the majority's extended analysis unnecessary and, with all due respect, problematic in some degree. The separate opinion explains my approach. So this is Kennedy's approach. O'Connor and Thomas are joining in what Kennedy writes here. The majority, of course, is correct to hold that when a judgment is presented to the courts of a second state, it may not be denied enforcement based upon some disagreement with the laws of the state of rendition. Full faith and credit forbids the second state from questioning a judgment on those grounds. There can be little doubt about this proposition. We have often recognized the second state's obligation to give effect to another state's judgments, even when the law underlying those judgments contravenes the public policy of that second state. My concern is that the majority, having stated this principle, proceeds to disregard it by announcing two broad exceptions. First, the majority would allow courts outside the issuing state to decline to enforce those judgments which, quote, purport to accomplish an official act within the exclusive province of a sister state. Second, the basic rule of full faith and credit is said not to confer injunctions, quote, which interfere with litigation over which the ordering sister state has no authority, end quote. The exceptions the majority recognizes are neither consistent with its rejection of a public policy exception to full faith and credit, nor are they in accord with established rules implementing the full faith and credit clause. As employed to resolve this case, furthermore, the exceptions to full faith and credit have a potential for disrupting judgments, and this ought to give us considerable pause. Our decisions have been careful not to foreclose all effect for the types of injustice or injunctions the majority would place outside the ambit of full faith and credit. These authorities seem to be disregarded by today's holding. For example, the majority chooses to discuss the extent to which courts may compel the conveyance of a property in other jurisdictions. That subject has proven to be quite difficult. Some of our cases upheld actions by state courts affecting land outside its territorial reach. Quoting Robinson v. Howard, 1913 case, it may not be doubted that a court of equity in one state in a proper case could compel the defendant before it to convey properties that are situated in another state. Nor have we undertaken before today to announce an exception which denies full faith and credit based upon the principle that the prior judgment interferes with litigation pending in another jurisdiction. As a general matter, there is a disagreement among the state courts as to their duty to recognize decrees enjoining proceedings in other courts. Subjects which are at once fundamental and so delicate as they ought to be addressed only in a case necessarily requiring the discussion, and even then With caution, lest we assume to announce rules which will not be sound in later application, we might be required to hold that if some future cases raises this issue, that otherwise valid judgment cannot intrude upon the essential processes of courts outside the issuing state in certain narrow circumstances. But we need not announce or define that principle here. Even if some qualification of full faith and credit were required, where the judicial processes of a second state are sought to be controlled in the procedural and institutional aspects, the court's discussion does not provide sufficient guidance on how this exception should be construed in light of our precedents. It's like a paragraph-long sentence. The majority's broad review of these matters does not articulate the rationale underlying its conclusions. In the absence of more elaboration, it is unclear what it is about the particular injunction here that renders it undeserving of full faith and credit. The court's reliance upon the unidentified principles to justify its omitting certain types of injunctions from the doctrine's application leaves its decision in uneasy tension with its own rejection of a broad public policy exception to full faith and credit. The following example illustrates the uncertainty surrounding the majority's approach. Suppose the Bakers had anticipated the need for Elwell's testimony in Missouri and had appeared in a Michigan court to litigate the privileged character of the testimony it sought to elicit. Assume further that the law on privilege were the same in both jurisdictions. If Elwell, GM, and the Bakers went before a Michigan court and Michigan law gave its own injunction preclusive effect, the Bakers could not relitigate that point if general principles of issue preclusion control. Perhaps the argument can be made that the majority appears to say that the integrity of the Missouri judicial process demands a ruling allowing relitigation of the issue, but for the reasons given below, we need not confront this interesting question. In any event, the rule would be an exception. Full faith and credit requires courts to do more than provide for direct enforcement of the judgments issued by other states. It also requires federal courts to give the same preclusive effect to state court judgments when those judgments will be given in the courts of the state from which the judgments emerged. Though full faith and credit and the local doctrines of res judicata, speaking generally, become part of a national jurisprudence. Riley versus New York Trust Company, 1942. And whether or not an injunction is enforceable in another state on its own terms, the courts of the second state are required to honor its preclusive effects. 2. Of Kennedy's concurrence. In the case before us, of course, the Bakers were neither parties to the earlier litigation nor subject to the jurisdiction of Michigan courts. The majority pays scant attention to this circumstance, which becomes critical. In the beginning point, a full faith and credit analysis requires a determination of the effect of the judgment has in the courts of the issuing state. In our most recent full faith and credit cases, we have stated that determining the force and effect of a judgment should be the first step in our analysis, quoting, if the state courts would not give preclusive effect to the prior judgment, the courts of the United States can accord it no greater efficacy under Section 1738. Quoting from Herring and Prossie, 1983 case, which quoted Union Planters Bank versus Memphis, a 1903 case. A conclusion that the issuing state would not give the prior judgment preclusive effect ends the inquiry, making it unnecessary to determine the existence of any exceptions to full faith and credit. We cannot decline to inquire into these state law questions when the inquiry will obviate new extensions or exceptions to the full faith and credit. If we honor the undoubted principle that courts need give prior judgment no more force or effect than the issuing state gives it, the case before us is resolved. Here, the Court of Appeals and both parties in their arguments before our court seem to embrace the assumption that Michigan would apply the full force of its judgment to the Bakers. Michigan law does not appear to support that assumption. The simple fact is that the Bakers were not parties to the Michigan proceedings, and nothing indicates that Michigan would make the novel assertion that its earlier injunctions bind the Bakers or any other party not then before it or subsequent to its jurisdiction. The collateral estoppel to apply under Michigan law, the same parties must have had full opportunity to litigate the issue, and there must be mutuality of estoppel. Since the Bakers were not parties to the Michigan proceedings and had no opportunity to litigate any of the issues presented, it appears that Michigan law would not treat legitimate any of the issues presented. It appears that Michigan law would not treat them as bound by the judgment. The majority cites no authority to the contrary. It makes no difference that the judgment in question is an injunction. The Michigan Supreme Court has twice rejected arguments that injunctions have preclusive effect in latter litigations, relying in no small part on the fact that the persons against whom the preclusion is asserted were not parties to any of the earlier litigation. Determining as a threshold matter the extent in which Michigan law gives preclusive effect to the injunction eliminates the need to decide whether full faith and credit applies to equitable decrees as a general matter or the extent to which general rules of full faith and credit are subject to exceptions. Michigan law would not seek to bind the Bakers to the injunction, and that suffices to resolve this case. For these reasons, I concur only in the judgment. Well, that was a bit long, but that was it, guys. Happy, it's still Easter. I didn't know how long I read. I thought maybe it was already the day after Easter, but it's still Easter. So happy Easter, everybody. Take good care. God bless you. Be safe. Love y'all. And I'll stream again soon, everybody.